Members of the jury, we are here today because the defendant, Ouchie Motor Company, put profits over people. On July 6, 2020, a car that Ouchie Motor Company put into the stream of commerce hit and fatally killed Miss Laura Miniger. And the saddest part about this story is that this easily could have been avoided had the defendant not put profits over people. Let's start with the driver, Miss Taylor Townsend. Miss Townsend worked at a local power plant 3 years prior to this accident. She decided that she wanted to make a little side money on the side hustle. So she began to be a rideshare driver. After a few rides, she decided and learned that she had a passion for being a rideshare driver. She learned that she wanted to make her experience for her clients as enjoyable and as safe as possible. So she began her research on the Ouchie Model T. She learned that the Ouchie Model T was rated as a level 4 on the autonomous driving scale. Members of the jury, being rated as a level 4 just basically means that the car will drive itself with no intervention from the driver itself, from the driver, him or herself. She was impressed. She furthered her research, and she saw that the defendant, Ouchie Motor Company, also produced advertisements showing, in the first 2 advertisements, showing a driver driving down the road with no hands on the wheel. In the 3rd advertisement, it depicted a driver once again driving down the road, yet this time nearly 50 miles an hour. But instead of hands near the wheel at all, or not on the wheel, or near the wheel at all, this time the driver had their hands on a book as it was going 50 miles an hour, depicting the driver as reading a novel. Members of the jury, these false marketing advertisements, as well as the design defect of the Model T, are exactly what happens when a company puts profits over people. People die. Members of the jury, my name is Joshua Cook, and along with my co-counsel, Russ Barnett, we represent the estate of Ms. Miniger in this action. We brought a case against the defendant, Ouchie Motor Company, for a design defect and/or a marketing defect of their Ouchie Model T. We must prove to you, members of the jury, that Ouchie Motor Company is more likely than not a producing cause of Ms. Miniger's death. More likely than not. You might be asking yourself, what does that mean? Members of the jury, more likely than not does not mean you need to be 100% positive that Ms. Miniger would still be here today. It doesn't even mean you need to be 75% positive, but rather that you need to be 50.01% positive that Ms. Miniger would still be here today had it not been for the defendant, Ouchie Motor Company, putting profits over people. As this trial begins, you're going to hear from a couple witnesses as well as a few experts. You're first going to hear from Officer Evan McCarthy, investigator for the Armadillo Police Department. She's going to tell you that when she arrived at the scene of the accident on July 6, 2020, she confronted a broken Taylor Townsend, saying things such as, the car was supposed to stop. The car was in ABS mode. She's further going to tell you that she asked Ms. Townsend if she could subpoena her phone records, and she even asked if she was being attentive, both of which Ms. Townsend agreed to and said that she was being attentive. They both showed these. Furthermore, the officer is going to tell you that she wouldn't have written a ticket to Ms. Taylor Townsend, but rather she would have written a ticket to the car company. Next, you're going to hear from Dr. Kerry Edlin. Dr. Edlin's going to lay out 4 simple ways in which Ouchie Motor Company cut corners and put profits over people. First, Dr. Edlin's going to explain to you that the software combined with the hardware of the Ouchie Model T should have, and easily could have, predicted and stopped the car from hitting Miss Laura Miniger on her bicycle. Second, Dr. Edlin is going to explain to you about the ADS chart and how the Ouchie Model T is a level 4 on the autonomous driving chart. Third, Dr. Edlin is going to explain to you a chart. He's going to illustrate a chart to you that shows the car 2.6 seconds prior to impact, accelerating and then braking, accelerating and braking, as it did not know what to do when the object came in front of the car, almost as it was messing up. And fourth, Dr. Edlin is going to give you a point of view from an average consumer and tell you what he believes the advertisements from the Ouchie Model T are to him. And finally, members of the jury, you're going to hear from the driver herself. Ms. Taylor Townsend. She's gonna tell you that on the day of the accident, she was being attentive. She's gonna tell you that when she was looking to find a new car that would make it as safe as possible, she looked towards the defendant, Ouchie Motor Company. She's gonna tell you that she believed in the ADS chart. She's gonna tell you that she believed in the advertisements by the Ouchie Motor Company. Members of the jury, do not take these statements lightly, as they will help us get justice for Ms. Miniger and whoever knows how much more that Ouchie Motor Company could do. At the end of today's case, my co-counsel is going to come offer you with some parting thoughts. He's going to lay out all the evidence, testimonies, depositions, put it all out on the table. And he's going to request that you hold Ouchie Motor Company liable for the death of Ms. Miniger as a producing cause from the marketing defect and or the product defect in the Ouchie Model T. And at the end of today's case, you'll see that when a company puts profits above people, people die. Thank you. Thank you, Your Honor.
Thank you. Counsel for the defense.
May I please report? Your Honor, opposing counsel, members of the jury. She had more than enough time. Taylor Townsend purchased the 2020 Ouchie Model T with hopes and expectations that far exceeded the car's actual capabilities. Nonetheless, for 2 months, she utilized the car without fault. She utilized the car for rideshare purposes to drive her passengers around. And with that, she became more comfortable. She became so comfortable that she'd look back at her passengers and say, "Look, no hands." And for 2 months, the car functioned as she had hoped, and everything was fine. That is until July 6, 2020. On this day, as the car was approaching Church and Market Street, it began to do something that it had never done before. It began to shudder, applying the brakes on and off, on and off, on and off, until it finally stopped, colliding with bicyclist Laura Menninger. But let's take a few steps back and realize, what was the car doing when it applied the brakes on and off? The car was telling Taylor Townsend that something was not right. The car was asking her for help, but Taylor Townsend did nothing. And as a result, Laura Menninger died. The car warned Taylor Townsend when it applied the brakes on and off, but she did nothing. But that does not dismiss the fact that she had more than enough time. Members of the jury, my name is Notori Weathersby, and I, along with my co-counsel, Alexis Cobbs, am representing Ouchie Motor Company Incorporated. Today's suit is being brought for the wrongful death of Laura Menninger. The plaintiff has a burden to prove that by a preponderance of the evidence, that means that more likely than not, that Ouchie Motor Company is at fault today. In today's trial, the defense did not have a burden to prove. However, we have given ourselves that same burden to prove that by a preponderance of the evidence, that Ouchie Motor Company is not liable by asserting an affirmative defense of comparative negligence. We will provide evidence and testimony from Dr. Gary Gleason, an engineering expert in autonomous driving vehicles, and he will testify that Ouchie Motor Company was not defective in its implementation, design, or marketing. Furthermore, we will provide testimony from Taylor Townsend, and she will testify to her experience on that day and what she did, but more importantly, what she did not do. And lastly, we will provide evidence that Ouchie Motor Company Incorporated provided ample evidence warning strictly, auto steer is a hands-on feature. Later on today, my co-counsel will come and she will discuss all of the evidence that we have presented and all the testimonies that you have heard. And she will ask that you find Ouchie Motor Company 0% liable for the death of Laura Menninger. And that is because the car braked on and off. It warned Taylor Townsend, but she did nothing. And that does not negate the fact that she had more than enough time. Thank you.
Thank you. Plaintiff ready to call his first witness.
Yes, Your Honor. Plaintiff calls Officer Evan McCarthy to the stand.
He may come forward now. She may come forward now.
Thank you, Your Honor. Your Honor, permission.
You may. The witness is under oath.
Can you state your name for the record?
Yes, Officer Evan McCarthy.
Officer McCarthy, where are you from?
I'm originally from Mexia, but I'm an investigator with the Armadillo Police Department.
Officer, did you go to school? Where are you from?
Yes, I went in the Lone Star area. I went to Lone Star State University.
Officer, what did you study when you were at this university?
Criminology and physics.
Officer, what did you do after college?
After college, I went directly into the Army. The recruiter said that I would be a great military police personnel and that I could pay off my student debts.
Officer, how was your experience in the Army?
It was great. I investigated a lot of accidents. I was a great fit and stayed until I paid off those debts.
Very nice, officer. Let's move on to the day of the accident, July 6th, 2020. How were you notified of this accident?
I received a call that there had been an accident on Market and Church Street, and so I went immediately to the scene.
Officer, what did you see when you arrived at the scene?
There was a mashed up bicycle that had just been hit by the Alchi Model T.
Officer, did you see a driver of this vehicle?
Yes, I saw and spoke with Taylor Townsend about the accident.
Did you ask Ms. Townsend what she was doing that day?
Yes, she said that she had bought this Model T from Alchi specifically for her rideshare business because it was a self-driving car and it would be safer for herself and then for her riders as well. And she said that on the day of the accident, the car had been working perfectly for the 2 months up until then, and she denied any kind of inattention at the wheel.
Officer, so she denied inattention. Did you look at her phone records?
Yes, it's pretty typical standard procedure to subpoena the phone records in these kinds of accidents. So I subpoenaed them from AT&T, but Ms. Townsend was very willing to comply because she claimed she wasn't on her phone at the time of the accident.
Officer, would you recognize these phone records if I showed them to you?
Yes,
Your Honor, permission to publish exhibit, permission to publish exhibit 4. I'm approaching opposing counsel.
All right.
What's been pre-marked. Your Honor, may I approach
You may.
this with the same? Officer, can you tell us what these are?
yes, these are the phone records of Ms. Taylor Townsend on the morning of the accident.
Is this have there been any material alterations since you last saw?
No.
Any additions or subtractions?
No,
Is this a fair and accurate copy?
yes,
Your Honor, permission to publish this as evidence?
Any objection?
No objection, Your Honor.
It will be admitted.
Officer, can you tell us what these tell you?
yes. The accident was at 9:12 in the morning and there's absolutely no phone activity at 9:12.
Officer, what about before 9:12?
Yes, it seems that there was a stream of texts coming in and out that morning during the ride, but the last text that was incoming was at 9:11. So that has nothing to do with if Miss Taylor Townsend was on her phone, that was just someone who was texting her.
Officer, is there a possibility that this stream of text could have been voice commands?
Sure, the Alchi Model T is a highly technologically advanced car, so it's definitely possible that voice text was a feature in the car.
Thank you, officer. Your Honor, permission to publish this as evidence that you're
Permission granted.
right. You're
That's fine.
Officer, have you ever been around autonomous driving vehicles before?
Yes, my sister actually tragically passed away from a similar incident.
Officer, I'm so sorry. Does that give you any bias to today's action at all?
No, absolutely no bias whatsoever.
Thank you. No further questions, Your Honor.
You may proceed.
Good afternoon, Detective McCarthy.
Good afternoon.
You've been a police officer with the Armadillo Police Department for 18 years, right?
Yes,
And in those 18 years, you've only investigated one accident involving an autonomous driving vehicle, is that correct?
That's correct, but my experience, I've been investigating for 18 years, and that includes all kinds of cars.
And the one accident that you have investigated involving autonomous driving vehicles is the one that we're here for today, is that correct?
Yes,
In fact, your only other experience involving autonomous driving vehicles involves the death of your sister, isn't that right?
yes,
You would agree that a driver should always be on the lookout when driving a vehicle, is that correct?
I mean, I think that's expected.
Detective McCarty, just for the record, the answer to your question is yes.
Yes,
And you would also agree that a driver should always control the speed of their vehicle, is that correct?
yes,
I want to move forward to the day of the accident, July 6, 2020. You received a text shortly after 9 that there had been an accident approaching Church and Market Street, is that correct?
yes,
And when you arrived at the scene, you conducted a thorough investigation.
yes,
So you took some measurements,
yes,
you took some photographs,
yes,
you interviewed Taylor Townsend, the driver of the car,
yes,
and you also interviewed witnesses, is that right?
yes.
And in all of your investigation, you didn't inquire about the surveillance footage at the local businesses or traffic cameras, did you?
That wasn't part of my initial consideration after the accident. I just wanted to get the photos and hear from the witnesses that were there.
Detective, for the record, the answer to that question is no.
Correct.
You interviewed Taylor Townsend, the driver of the car. In your interview that you conducted, didn't you uncover that Taylor had been utilizing the autonomous driving feature?
Yes, it was on at the time of the accident.
And you also interviewed the passenger who was in the car with her, Mr. Massel, and he testified, right?
Yes,
And he told you that he was uncomfortable with the fact that Ms. Taylor was relying so heavily on the autonomous driving feature, didn't he?
he gave me some information about the ride before the accident, but he wasn't paying attention the moments directly before the accident, and that's what I really needed to know.
And Ms. Taylor told you that she was not inattentive while she was driving the car, isn't that right?
Yes,
And she told you that she had not been texting at the time, isn't that right?
she denied any kind of using her phone during the time of the accident at 9:12.
Despite her denials, you still inquired with AT&T to get her cell phone records, didn't you?
It's pretty standard procedure to obtain this kind of information, so that's what I did for this accident too.
And after looking at the cell phone record, would you recognize that if I showed it to you today?
Yes,
Your Honor, the defense is retrieving what has been admitted as exhibit 1. Permission to approach opposing counsel and witness.
Granted.
Your Honor, the defense also has a courtesy copy if you would like to see it.
Okay. Thank you.
Detective McCarty, a few moments ago, you said that Taylor Townsend had been texting while driving the car, isn't that correct?
yes, during the ride, she had received some texts coming in and out, but not right before the accident. At 9:12, there's nothing here.
And the accident occurred at 9:12, isn't that correct?
Yes, that's correct.
And there was a phone call placed by the Alchi Motor Company car at the time of the accident, and a call log provided from the sheriff's department. Would you recognize that if I showed you today?
Yes,
Your Honor, the defense is retrieving what had previously been marked as exhibit 18. Exhibit 13, correction. Permission to approach witness and opposing counsel.
Granted.
Detective McCarty, what have I just handed you?
this is a transcript from the 911 call that the Alchi Model T made to 911.
Does it appear to be changed or altered in any way?
No.
Is it the same as the last time that you saw it?
Yes,
And in this report, at the top, it says that the accident was took place like what time?
At 9:12.
Okay, I'll take that back from you now. Permission to publish exhibit 13 to the jury.
Any objection?
No objection, Your Honor.
Okay, it is admitted.
Now, Detective McCarty, I want to refer back to the cell phone record that we referenced earlier. You said that she had not been texting at the time leading up to the accident, which happened at 9:12, correct?
I said that at the time of the accident, she was not texting, and there's nothing here at 9:12.
But moments before she had been texting.
Sure, during the ride before she had received and sent some text.
Can you tell us that the last time on the call log that Ms. Townsend sent a text message?
Yes, that would be prior to the accident.
Yes, the time marked
Yes, that would be at 9:10. She sent an outgoing text.
and the one immediately following.
She received the text at 9:11.
So it is true that this call log refers that Taylor Townsend had been texting moments before the accident. Is that correct?
Minutes before, yes.
And from your investigation, you revealed that Taylor Townsend had been inattentive while driving. Isn't that correct?
She denied any kind of inattention at the time of the wreck.
Yet she received a citation for failure to control the vehicle. Isn't that correct?
The patrolman issued that ticket. I definitely wouldn't have. I would have given it to the car company. It's a self-driving car and it ran into a bicycle.
But Detective McCarty, did Taylor Townsend receive a citation from an authorized police officer with the Armadillo Police Department for failure to control the vehicle?
Yes, she did.
No further questions. Permission to retrieve the document. please.
You may.
Thank you.
Any redirect?
Yes, Your Honor. Ready for you all.
You may proceed.
Officer, a citation was just mentioned. Can you tell me about it?
Yes, the patrolman that was on duty at the time of the accident issued a ticket to Taylor Townsend, but it's definitely not what I would have done.
You wouldn't have written a ticket. You wouldn't have wrote a ticket.
No, I wouldn't have. I would have given the ticket to the car company, if anyone. I mean, it was a self-driving car and it ran right into Miss Vinegar.
Let's move on to the witnesses. Was there anybody in the car with Miss Townsend?
Yes, Peter Musso was riding. She was delivering him through her rideshare business at the time of the accident.
Did you talk to Peter?
Yes, I did.
What did Peter say about the moments or the minutes before the accident?
He said that the minute or two right before the accident, he was still flipping through his file that he was preparing for his meeting, and he wasn't looking at Miss Townsend.
What about at the time of the accident, 9/12?
He had no information about what Miss Taylor Townsend was doing or not doing because he was flipping through his file.
Very nice, officer. Were there any more witnesses?
Yes, I also interviewed Luke Dushot, who was in a nearby vehicle at the time of the accident.
Did Luke see Miss Townsend?
He also didn't make any mention of Miss Taylor Townsend at the time of the accident. So he has no information about that as far as I could tell.
No further questions, Your Honor. May the witness.
The witness may step down and is excused.
Thank you, Your Honor.
Plaintiff may call us next witness.
Yes, Your Honor, at this time, I'd like to call Dr. Perry Edwin.
Your Honor, may I have permission to reposition myself to well so that I can see the witness?
You may. Witness is considered sworn.
How you doing today, sir?
Doing well, how are you?
Doing all right. Can you state your name for us, please?
Yes, my name is Dr. Kerry Evelyn.
And where do you currently reside, Doctor?
I live in the city of Macon here in Lone Star.
Can you tell us a little bit about your educational background?
Yes, so for my undergraduate studies, I attended MIT, Massachusetts Institute of Technology, where I received my bachelor's in engineering. After my time at MIT, I attended Lone Star A&M University, where I received both my master's and PhD in biomechanical engineering.
And what did you do after receiving your PhD, Doctor?
I began working with American car companies to design and implement their driving systems in their vehicles.
How long have you been doing that for?
20 years.
And what is your current occupation?
I'm a consultant in the field of developing and implementing vehicle autonomous driving systems or ADS systems for car companies.
Have your opinions ever been published?
They have been.
And are you familiar with the ADS system at issue in this case?
Yes, it's actually very similar to the systems that I work with on a daily basis.
Your Honor, this time plaintiff formally moves to certify Dr. Carrie Edwin as an expert in ADS systems.
Any objection?
No objection to a certification as an expert. But before the expert gives his conclusions, we would ask that testimony be elicited to fulfill the rest of the prongs of Rule 702.
All right, the witness is accepted as an expert.
Dr. Edwin, have you formed any opinions in connection with this case?
I have.
And what facts or data have you relied upon to reach those conclusions?
Well, as typical, I relied on the scientific information that was pulled from the vehicle itself, as well as other witness testimonies and pieces of evidence that were provided to me.
Was there enough information available for you to reach a proper conclusion?
There was.
And what principles or methods did you utilize in your analysis?
Standard procedure, I began my analysis by looking at the scientific data that was pulled from the vehicle itself. Took some conclusions from that document and then paired that with the other information that was made available to me. And I used that to comprehensively form my conclusion.
Thank you, Doctor. And what opinion have you formed about the optionality of this case?
Well, I believe that the Ouchie Model T was both unreasonably dangerous and defective from the time it left Ouchie Motor Company.
What specifically about this vehicle did you find to be unreasonably dangerous or defective?
Well, in my opinion, there are 4 distinct areas of defect on the Ouchie Model T. First area is that the vehicle should have been able to detect the bicycle as it was approaching from the side street, and it failed to do so. Secondly, the car's internal impact mitigation logic was overridden by design by the car's internal computer. And instead, at the moment, the car was relying solely on driver intervention as related to avoiding the bicycle. Lastly, the car contained an insufficient driver engagement system, which is designed to ensure that the driver remains attentive and with their hands on the wheel throughout the entire drive. And lastly, the ad campaigns run by Ouchie Motor Company misled consumers into believing that they did not have to pay attention while they were behind the wheel of the vehicle.
Okay, Doctor, that was a lot of information at once. Let's see if we can break this down a little bit. Can you tell us about your initial opinion about the optionality?
Certainly. So the Ouchie Model T should have been able to detect the bicycle that was approaching the vehicle from the side street through its sensors and other means of detection on the vehicle itself, and it failed to do so.
And how were you able to determine this?
I determined this by looking at the time readout from the car itself, immediately leading to the accident.
Would you recognize this readout if I was to show it to you?
I would.
Your Honor, this time I'm approaching opposing counsel, was previously marked exhibit 15. May I approach the witness?
You may.
Is this the readout that you just mentioned, Doctor?
Yes, sir.
Have there been any material changes or alterations made?
No, sir.
So this is a fair and accurate copy of the readout that you analyzed.
Yes, it is.
Objection, Your Honor. Leading question.
Your Honor, I'll rephrase.
Rephrase, please.
Is this a fair and accurate copy?
Yes, it is.
Your Honor, at this time plaintiff moves to have exhibit 15 admitted to evidence.
Any objection?
None at all, Your Honor.
It will be admitted.
Also, Your Honor, we would like permission to display our demonstrative during this question.
Granted.
Doctor, were you able to see for this angle? I'd like for it to be able to be visible for you and the jury.
Yes, I can see.
All right, good deal. Okay, Dr. Edwin. What information is being shown to us on this readout?
Well, as it says at the top, this is the event recorder data that was pulled from the Ouchie Model T vehicle that was in the accident itself. In the first column, we see time denoted in tenths of a second going from 4 down to 0.00. And these cycles represent the 4 seconds represented in tenths of a second, immediately leading to the collision itself. The second column indicates whether or not the braking system was engaged at the time the information was recorded. And the third column represents the accelerated position at the time. The fourth column then indicates which sensors on the vehicle were activated, with right front for RF, right bumper, RB, and SC as front center. And lastly, the fifth column depicts speed in miles per hour.
Okay, Dr. Edwin, how does this readout help inform your opinion?
Well, it tells me that the vehicle was unable to come to a conclusion as to what exactly was detecting when it first noticed that the bicycle was approaching.
And at what point was the vehicle able to finally identify that an object was in the way?
At 0.6 seconds prior to the collision.
Was this enough time to prevent this accident?
At that speed, no.
Dr. Edwin, is there a widely available alternative to this sort of software?
Yes, car companies are able through, both hardware and software to employ an array of sensors and other detection means on the vehicle itself to detect when objects are approaching your vehicle that might need to be avoided.
Thank you, Doctor. Moving on, can you tell us about your second conclusion in this case about the Model T?
Yes, my second opinion is that the car's internal computer inappropriately disengaged the vehicle's impact mitigation system. Instead, in the moments immediately prior to the collision, it was relying only on driver intervention as it related to the obstacle.
Can you explain that further for the jury?
Certainly, so, the way that, these vehicles are designed with the ADS software, they're able to detect when an object ideally is approaching from any angle, that any object that might come into the field of the vehicle as it's in motion. When the ADS system is engaged, this software is intended to be able to stop the vehicle before collision if the driver is unable to stop the vehicle. However, in this situation, with this Algae Model T, that impact logic was overridden by the car software itself. And instead, the vehicle was relying only on driver intervention while it was engaged.
So, Dr. Evelyn, in your opinion, if this reliance had not been in place, could this collision have been prevented?
Very likely would have.
Dr. Evelyn, what is your opinion regarding the driver engagement system?
I believe that the driver engagement system on the car is too insufficient to be deemed safe.
Can you explain that a little bit further?
Certainly.
What can car manufacturers do about this?
So a driver engagement system is a system that is in the car with an ADS software that ensures that drivers maintain the action of driving while they're behind the steering wheel. Be it sensors on the steering wheel itself that will alert a series of beeps to the driver to let them know it's time to resume the task of driving, or even sensors that detect driver eye movement, and if his eyes are removed from the road for too long a period, the car will similarly alert the driver that it's time to resume driving. Neither of those easy means were available on the Algae Model T.
Are these types of systems expensive to install?
They're not.
Did the Algae Model T have any of these systems in place?
No.
Dr. Evelyn, what would you say to an expert who says that no defect was present in the Algae Model T?
I would say that that's incorrect.
Why would you say that?
Well, it's my opinion that any expert in my field, having been given the opportunity to review the same information that I have been, that they will walk away from this similar conclusion to that I've reached.
Do you have any other opinions in this case?
Yes, lastly, I believe that the advertising campaigns run by Algae Motor Company inappropriately misled drivers into thinking that they did not have to fully pay attention while behind the wheel.
Would you recognize these advertisements if I were to show them to you?
Yes,
Your Honor, at this time, I'm approaching opposing counsel, will bring some more exhibits 7, 8, and 9. Dr. Evelyn, are these advertisements?
they are.
Can you briefly explain to us what these are?
Yes, these are each 3 screen grabs from television advertisements for Algae Motors.
Has there been any material alterations or changes made to these?
No, sir.
Is this a fair and accurate copy of the advertisements that you were able to review?
Yes.
Your Honor, at this time, plaintiff moves to have exhibits 7, 8, and 9 admitted into evidence.
Any objection?
Yes, Your Honor, specifically to exhibit number 9, this document contains impermissible hearsay. Can I explain?
You might.
Ordinarily, hearsay is an out-of-court statement being used for the truth of the matter asserted. Normally, that comes in the form of an oral or written statement. However, nonverbal conduct also counts as a statement in some circumstances. It is the defense's belief that the plaintiff is using this document to basically tell the jury that Algae Motors told Taylor Townsend that she could sit in her car and read a magazine. And that's a hearsay statement, Your Honor.
Your Honor, may I respond?
You might, please.
Plaintiff has no intention of making such an argument. We're asking the expert's opinion on how the advertisements were misleading to the public, Your Honor.
Anything further?
Yes, Your Honor. The plaintiff's entire case is formulated around the assertion that Algae Motors impermissibly advertised their vehicle, which means they are asserting that Algae said that this was okay using this advertisement, which is an out-of-court statement that they are using for the truth of the matter asserted.
The objection will be overruled. I think it is the advertising is one of the main issues in this case. So it will be admitted.
Yes, Your Honor. Doctor, before the interruption, these advertisements, can you, also, Your Honor, permission to display or demonstrative during our question?
Granted.
Okay, Doctor, can you briefly tell us your opinion about these advertisements?
Well, I believe that they give a dangerous false impression. If we look at exhibit 9 here, we see, Alchemy Motors depicting a driver of one of their vehicles traveling down the road at nearly 50 miles an hour. And not only are both their hands removed from the steering wheel for a long enough period to be dangerous, but they're reading what appears to be a magazine or a book. And this lack of attention that they are advertising to their drivers as being necessary to effectively drive their vehicle, in my opinion, is dangerously misleading and even fatal.
Dr. Evelyn, did Alchemy provide any warnings to its consumers?
They did provide warnings, but in my opinion, they were too insufficient and inadequate to appropriately cover the risks associated with the vehicle.
Well, were warnings provided in the owner's manual?
They were.
Did you review the owner's manual?
I have.
You would recognize it if I would show you a copy?
I would.
Your Honor, at this time, I'm approaching the opposing counsel and look for increases marked exhibit 6. Is this the owner's manual that we just mentioned?
Yes, it is.
Can you briefly review that for us? And have there been any material changes or alterations made?
No, sir.
No deletions or anything of that sort?
No, sir.
Is this a fair and accurate copy of the owner's manual that you reviewed?
Yes, sir, it is.
Your Honor, at this time, plaintiff moves to have exhibit 6 admitted to evidence.
Any objection?
None at all, Your Honor.
It is admitted.
Dr. Evan, what are your opinions about the warnings provided in this owner's manual?
Well, while there are warnings provided in the owner's manual, I believe that, as I said earlier, they are too insufficient to appropriately cover the risks associated with this vehicle. If we look at the amount of attention in the manual itself that is given to the driving system, it covers only 4 pages. But if we look at the amount of space in the owner's manual itself, it's dedicated to the infotainment system or the entertainment system of the car, over 10 pages of information and instructions are given. This discrepancy in attention to me highlights at least an indifference to the amount of attention the driver is acting in while they're operating the vehicle.
Is this discrepancy a defect in your opinion?
It's definitely misleading.
Thank you, Dr. Evelyn. And briefly, what was your opinion in this case today?
My opinion comprehensively was that the Alchemy Model T was both unreasonably dangerous and defective from the time it left Alchemy Motor Company.
Have you reached these opinions with a reasonable degree of scientific certainty?
I have.
Are you confident in these conclusions, Doctor?
I am.
Thank you, Dr. Evelyn. No more further questions, Your Honor.
May I ask the opposing counsel to remove the stand from the well?
I apologize.
Of course.
May I also move the podium?
You may.
May I proceed, Your Honor?
You may.
Good afternoon, Dr. Evelyn. I'd like to talk about some of the defects that you claim exist in the Alchemy Model T's design. So it's your belief that the system should have been able to detect the bicycle even though it was coming from the side?
Yes.
It's also your belief that if Miss Townsend's attention had been brought to driving, then she could have seen the obstacle in time to avoid the collision.
Yes.
So you think that the car should have been equipped with sensors on the side?
Yes.
And you think that the system should have had a driver engagement system?
Yes.
But the car actually did detect the bicycle, didn't it?
There were a period of time where it was uncertain as to what it was detecting, but there was something detected.
Well, I want to talk about that a little bit more. Permission to approach the witness with what's already been entered as exhibit 4?
Granted.
Exhibit 15, Your Honor, apologies.
Mhm.
Does Your Honor have a copy?
Is this 15?
Yes, Your Honor.
I do.
So I want to make sure that the jury is clear exactly what we're looking at, Dr. Evelyn. So this first column, it indicates comp, right?
Yes,
And this data starts 4 seconds before the accident.
that's right.
The second column indicates whether or not the brakes were on or off.
Yes.
And this fourth column tells us whether the sensors were activated.
Yes.
And it tells us which sensors were activated.
Yes.
So the car first detected the bicycle at 2.6 seconds before the crash, isn't that right?
According to the data,
And the car actually attempted to warn the driver about it, didn't it?
I don't know that I would characterize that as a warning so much as a malfunction of the vehicle itself, but
Well, the car braked, didn't it?
rapidly releasing the brakes and unreleasing the brakes, yeah.
Yeah, it released and it unreleased over and over again, right?
Yes,
And it's your opinion that a driver would have felt this happening?
most likely,
It would have felt like a kind of stutter, wouldn't it?
probably,
Well, no, not probably, Dr. Evelyn, that's what you believe it would have felt like, right?
yes,
And it would have felt like the stuttering you feel when braking on an icy road, isn't that right?
yes,
And this feeling would be happening for those 2.6 seconds?
presumably,
So it's your belief that a driver who was paying attention would have been able to feel this and stop the car in time?
most likely.
I'll take that document back from you. It's also your opinion that Ms. Townsend actually may not have been paying attention in the moments before the accident, isn't it? True?
She might not have been, there were certainly distractors in her environment, but I don't know that I can say for certain that she was distracted, but that there were distractors.
So just to be clear, you believe that she may not have been paying attention?
She might not have been.
And you think that a great indicator that she might not have been paying attention is the fact that she took no evasive action at all before the crash, right?
Well, I've never said that she didn't take any evasive action. I don't know that she was distracted fully or not. I don't know that I can say concretely whether or not she was distracted.
Is it your testimony today that you don't believe the driver took no evasive action?
Well, it's my testimony today that I can't say concretely that she did from the data that I've been given.
You remember preparing testimony before trial,
Yes,
and you recognize that testimony if I showed it to you?
yes,
Permission to approach the witness and opposing counsel with his previous statement.
Granted.
A moment, Your Honor. All right. Would Your Honor like a copy?
I have a copy.
All right. Here you are. Now, this looks like a copy of your prior testimony, doesn't it?
yes,
Exactly the same as it was last time you saw it?
yes.
Hasn't been changed or altered in any way?
No, that I can tell.
And if you'll turn to this last page with me. That's your signature.
Presumably.
All right, Dr. Evelyn, I'm gonna ask you to turn to page 6 with me. And I'm gonna ask you to read along silently while I read aloud from line 11. However, because no evasive action was taken by the driver before the impact, one must assume that the driver was not paying attention to the task. Did I read that correctly?
Yes,
I'll take that document back for now. I want to talk about what else you reviewed before coming to court today. You talked a little bit about the owner's manual that you reviewed on direct examination. I'd love to revisit that.
Okay.
I'm gonna approach the witness now with a copy of Exhibit 6. Now, Dr. Evelyn, this document contains all the parts of the owner's manual that you reviewed, right?
yes,
And you used this to come to your conclusions?
yes.
But you didn't actually review the entire manual, did you?
I reviewed this portion of the manual that was provided to me.
No, I want to make sure that everybody's clear exactly what you reviewed. So this document, it goes from page 110 to page 119. Right?
Yes, presumably, yes, in this fact.
And then it skips to page 314
Yes,
and goes to page 317.
yes,
So that's what, a total of 15 pages if you include the title page that you reviewed?
yes,
And this manual has at least 317 pages, doesn't it?
according to table of content.
So now I want to talk a little bit about what you saw in those 15 odd pages that you actually reviewed. If you'll look with me on page 314, just let me know when you get there.
From there,
So you see on this page a word that says caution, right? Don't you?
yes,
And that's in red,
yes,
it's bold,
yes,
it's in all caps.
yes.
Can you read the last two sentences for the court under caution?
Auto steer is a hands-on feature. You must keep your hands on the steering wheel at all times.
You'd agree with me that this is a warning to the driver?
It is a warning, yes.
You'll turn to the next page, 315. You see a large black box in the middle of this page, don't you?
Yes,
It says warning in it.
yes,
It's got a caution sign.
yes.
Can you read those first two sentences under warning for the court?
Navigate on autopilot does not make driving autonomous. You must pay attention to the road, keep your hands on the steering wheel at all times, and remain aware of your navigation route.
Now, there's also some bolded writing on this page.
Yes.
Can you read the bolded writing for the court?
Do not take your eyes off the road for extended periods of time. Do not remove your hands from the wheel at any time.
You'd agree with me that that's two more warnings, right?
I'd say it's really just one big warning, but.
Well, there's the bolded part and the non-bolded part, right?
Yeah.
So in the 15 or so pages out of 317 pages at least in the manual, there were 3 warnings to the driver about the LG system's limitations, right?
At least 2, yes.
Dr. Evelyn, you're aware that there are actually at least 10 warnings in this owner's manual, right?
Yes,
You didn't see them because you only look at these pages,
I'm worried they're in there.
but you didn't look at them.
None in this section that was provided to me.
Okay, I'll take that document back from you now. I actually want to talk about how it is that we know that there were more warnings in this owner's manual. So you also reviewed an NTSB report to come to your conclusions, right?
Yes,
And you recognize that NTSB report was showed to you?
yes,
I'm now approaching opposing counsel and the witness with exhibit 14. The last 2.5 pages have been constructively redacted per your honor's previous ruling. Would you like a copy?
I have a copy, thank you.
Now, this looks like that NTSB report you reviewed, right?
yes,
Hasn't been changed or altered in any way?
no,
Is exactly the same as the last time you saw it?
yes,
And just to be clear, you relied on this report to help come to your conclusions?
yes.
All right, at this time, the defense moves to enter exhibit 614 into evidence.
Any objection?
No objection, Your Honor.
It is admitted.
If you'll turn with me to page 6, Dr. Evelyn. Now, from this page, you know that the Ouchie's manual had at least 10 warnings about the system's limitations, right?
Yes,
But this page also tells us that Ouchie provided additional warnings to the driver outside of the manual, right?
yes,
And these warnings came in the form of an alert system every single time a driver engaged the autopilot system, right?
at the time of activation, yes.
And you have no reason to believe that Taylor Townsend didn't see these alerts, right?
No reason to believe that.
No reason to believe that she didn't have to make certain acknowledgements.
No.
So I want to talk about what exactly it is that Taylor Townsend had to acknowledge before activating the autopilot system. So Ms. Townsend had to acknowledge that auto steer is a feature currently in beta, isn't that right?
Yes,
Ms. Townsend had to acknowledge that auto steer is a driver assistance feature and does not make your vehicle completely autonomous.
yes,
Ms. Townsend had to acknowledge that she should only use this feature if she is willing to pay attention to the road, keep her hands on the steering wheel, and be prepared to take over anytime. Is that right?
yes,
Now, she also had to acknowledge that auto steer is designed for use on highways that have a center divide, clear lane markings, and no cross traffic. Is that right?
yes,
And you would agree with me that on the day of the accident, Ms. Townsend wasn't on a highway, was she?
no,
And she was in cross traffic.
yes,
Ms. Townsend also had to acknowledge that she should read the owner's manual before using that feature, right?
yes,
And Dr. Evelyn, every single time that Ms. Townsend engaged that system, she got an alert, didn't she?
presumably,
Well, not presumably, that's what you know, right?
as long as the car was operating correctly, yeah.
Well, she would have gotten an alert that she needed to always keep her hands on the wheel, right?
Yes,
And she would have gotten an alert to tell her, be prepared to take over at any time.
yes.
Thank you, Dr. Evelyn. I have no further questions. I'll retrieve that document from you now. Permission to public to the jury?
Granted.
Three for your record. Dr. Evelyn, do you own a car?
I do,
Does that car have an owner's manual?
it does.
Have you read every single page of that owner's manual?
Not a chance.
Have you been paid to testify in court today?
No.
Nothing further, Your Honor.
May this witness be finally excused?
Yes, Your Honor.
Okay, thank you. You may step down. Does the plaintiff have any additional witnesses?
Your Honor, this time the plaintiff rests his case in chief.
All right. Is the defense ready to proceed with its case?
Before we proceed, Your Honor, the defense would like to move the petition for under federal rule of civil procedure 50A, or just a moment, Your Honor, apologies.
This is a motion to be made outside the presence of the jury,
Yes,
so
Your Honor.
we'll just assume the jury has been excused.
Thank you, Your Honor, just a moment. Your Honor, the defense would like to move pursuant to a federal rule of civil procedure 50A for a judgment as a matter of law. At this time, at the conclusion of plaintiff's case in chief, they have not proven by a preponderance of the evidence their burden. Specifically, what they have not proven is that absent anything else, that the Algae motor system is the cause of Ms. Miniger's death. Specifically, they have not proven that Algae had any knowledge of defects, and that's what they purported that they had to choose. Without that knowledge element, we can't proceed, Your Honor.
What says the plaintiff?
Your Honor, a reasonable jury would have a legally sufficient basis to find for the plaintiff in this case. We have a burden to show a defect either in marketing or in the design itself, and we have easily shown this by preponderance of the evidence through the testimony of Dr. Kerry Evelyn, where he listed specific defects that occurred and in absence thereof would not have produced this accident. We have met our burden.
May I respond, Your Honor?
You may.
An essential part of the plaintiff's burden is that they had to prove that Algae Motors Incorporated had knowledge of any defects. There's been no testimony elicited that shows that at all.
Are you sure that they have to have knowledge of a defect?
Yes,
It's you're saying it's a defense to a defective design that, oh, I didn't know that it was defective.
Yes, Your Honor, the plaintiff had to prove that Algae had knowledge of this defect and could have taken measures to correct it, pursuant to this court's prior jury instructions.
Counsel.
Your Honor, the plaintiff has shown that the defects were unreasonably dangerous at the time that they left the hands of Algae and were entered into the stream of commerce. That was our burden, and we have done that. We have met that burden, and any reasonable jury would have sufficient legal basis to find for us in this matter.
Can you point to me in the jury instructions where it says they have to have knowledge of the defect?
Yes, Your Honor, just a moment. And that would be, I believe, the last, you have the jury instructions, Your Honor?
I do.
Yes, Your Honor. Yes, Your Honor, on the, I believe it's page 88 of the record.
I'm looking at that page.
Yes, at the bottom of this page, it tells you what a design defect is. It has to have been unreasonably dangerous as designed, taking into consideration the utility of the product and the risk involved in use. For a design defect to exist, there has to have been a safer alternative design, which means a product design other than the one actually used that a reasonable probability would have prevented or was economically and technologically feasible. In order for there to have been an economically and technologically feasible one for feature for Algae to even implement in the first place, they had to have had knowledge of the defect in the first place.
I don't agree with that. I don't infer knowledge as an element of this cause of action. Just negligence is what we're looking at, and so I'm going to deny the motion.
Yes, Your Honor.
Are there any other motions before we bring the jury back in?
No, Your Honor.
Okay. All right, we've brought the jury back in, and the defense may call its first witness.
Yes, Your Honor. At this time, the defense calls Taylor Townsend to the stand. Ms. Townsend, could you please introduce yourself to the court?
Yes, my name is Taylor Townsend, but you can call me Tay Tay.
What do you do for a living, Ms. Townsend?
Oh, I've got a couple different jobs. I'm the assistant of the deputy of operations at a local power plant, and I'm a rideshare driver on the side. I'm trying to make enough money so I can become a full-time skier and, I don't know, move somewhere like Antarctica.
Okay, Ms. Townsend, what brought you to court today?
I think like July 6, 2020, there was a terrible accident. I hit a girl with my car.
What kind of car were you driving at the time?
Oh, a white Alchemy Model T, one of those self-driving cars.
What inspired you to buy the Algae Model T?
Well, like I said, I'm a rideshare driver on the side, and I don't know, I just kind of figured make my long rides more comfortable, more fun.
How could it make your long rides more comfortable and fun?
Well, like, how cool would it be, on my long rides, get some extra tips, turn around my passenger and be like, look, no hands.
Ms. Townsend, did you do any research before purchasing the Algae Model T?
Oh, absolutely. I would never make such an important decision without doing my due diligence first, so I did like 6 months of research.
Can you tell the court exactly what your due diligence looked like?
Yeah, I read an article and, looked at some ads. I figured, self-driving cars are complicated, so.
Okay, Ms. Townsend, after you purchased the Algae Model T, did you receive any additional information?
Yeah, all cars come with owner's manuals, right?
Would you recognize a copy of that owner's manual if I showed it to you?
Yes.
Permission to approach the witness with this already been entered as Exhibit 6.
Granted.
What items handed you?
The Ouchie Model T owner's manual.
Did you read any of this manual before you started operating the car?
I sure did. I read the infotainment system. That was really all I cared about. Nothing else seemed that important.
Well, I want to take a look at exactly what it was that you read. So if you'll turn with me to page 110. Does anything on this page stick out to you?
There's a little box kind of set distinctive to the side. It's a warning.
Could you read the first 2 sentences of that warning to the court?
Taking your eyes off the road for too long or too often while using any infotainment feature can cause a crash. You or others could be injured or killed.
Do you remember reading this before beginning to operate the car?
Well, it's in the infotainment system, so yeah.
Okay. Well, can you turn with me to page 314? Does anything on this page stick out to you?
There's the word caution, and it's in all capital letters in red.
Could you read the last 2 sentences under caution for the court?
Auto steer is a hands-on feature. You must keep your hands on the steering wheel at all times.
Do you remember reading this before beginning to operate the vehicle?
No.
Okay, Ms. Townsend, let's look at page 315. Anything stick out to you here?
Yeah, there's one of those little warning boxes with like a caution symbol.
Can you read what's under the caution symbol?
Navigate on autopilot does not make driving autonomous. You must pay attention to the road, keep your hands on the steering wheel at all times, and remain aware of your navigation route.
Anything else on the page stick out to you?
There's some more bold words underneath.
What do the bolded words say?
Do not take your eyes off the road for extended periods of time. Do not remove your hands from the wheel at any time.
Do you remember reading anything on this page?
No, like I said, I only cared about the infotainment system. I really did not care to read anything else.
Okay, I'll take that document back from you, Ms. Townsend. I'd now like to direct your attention back to the day of the accident. That was, what day was that again?
July 6th, 2020.
So how did that morning start for you?
Oh, it was like any other morning. I would rideshare pickup, have my passenger in the back. We're on our way to his office and, just driving down Market Street.
Were you using your phone at all?
No, I would never do anything like that.
Do you remember how often you used your phone that day at all?
Well, I mean, I definitely used it.
How how recently before the car crash were you using your phone?
Well, I think the accident occurred around 9:12 a.m. and I was probably sending some text messages a little bit, couple of minutes before that.
Were you using any kind of voice to text system?
No, I don't even know how to do that.
Okay, at that point, was the car driving itself?
Yes.
So, and when did you realize that something was wrong?
Well, I kind of felt this little stuttering going on, on and off, and kind of felt like the car was trying to brake.
How did you react to that feeling?
Well, I didn't know what to do at first, and so I grabbed the steering wheel and I tried to brake, but it was too late.
So at what point did you first see the bicycle?
I mean, I can't tell the distance exactly, but I saw her at the corner of my eye.
So, Ms. Townsend, I just want to be very clear for the court of something you just said is kind of bothering me. You just said that you grabbed the steering wheel before the car crashed. At any point during that drive, were your hands off the wheel?
It's possible.
Okay, Ms. Townsend, I have no further questions.
You may proceed.
Good evening, Ms. Townsend. My name is Joshua Cook, and I'm just gonna ask you a couple questions here today. If you could answer in a yes or no, we can get you out of here just as soon as possible. Does that sound good with you?
Sure.
You were the driver of this Alchemy motor vehicle on July 6th, 2020. Is that right?
Yes.
You were operating your car as a rideshare driver, yes?
Yeah.
You had been a rideshare driver for quite some time before that. Is that right?
Yeah. Try to save up some money.
You stated that you wanted to get a new car after a few rides. Is that right?
Yeah.
You started some research to get some new cars. Is that right?
Yeah, like I said, I read an article and I don't know, saw some ads.
You saw an autonomous driving chart. Is that right?
Possibly.
Would you recognize it if I showed it to you?
Sure.
Your Honor, permission to approach opposing counsel with what's been remarked in 616.
Granted.
Counsel. Your Honor, permission to approach the witness and use our demonstrative.
You may. You may.
You see that okay, Ms. Townsend? Just want to make sure.
Yes.
Ms. Townsend, this is the chart that you saw, is that right?
I believe so.
Is this a fair and accurate copy of the last time you saw it?
Yeah.
Have there been any material alterations or deletions?
Not that I can tell.
No additions or subtractions?
No.
Your Honor, permission to use this as evidence.
Any objection?
No objection, Your Honor.
Ms. Townsend, you said that you were looking for a level 4. Is that right? A level 4 on this chart?
I don't recall saying that today.
You did say it in prior to today. Is that right?
Possibly, I really don't remember.
Is that a yes, Ms. Townsend?
I don't remember what I said previously.
Ms. Townsend, you said that you were looking for a level 4. You said on Your Honor's permission to look at number 19 of the testimony, or paragraph or sentence 19 of the testimony, Ms. Townsend. The question was, what's a level 4? And you said this level is what I was looking for prior to that.
Okay.
Objection, Your Honor, to the attorney testifying.
Your Honor, I was just telling her, I was pointing her in the direction.
I think he was asking if that was her testimony at the deposition. I believe you got an answer, but if you feel like you didn't, you're free to ask that question again.
Yes, Your Honor, just to be clear, you were looking for a level 4, is that right?
I don't remember saying that, but yes,
Okay. Is there any way that, can you tell us what level 4 means? It's right here, I'm sorry. Yeah. There.
you'd like me to just. read
Yeah,
it?
just what those 3 words say.
High driving automation,
Can you tell us what this sentence says?
which sentence?
The one right to the right of it.
The sustained and ODD specific performance by an ADS of the entire DDT and DDT fallback without any expectation that a user will respond to a request to intervene.
Ms. Townsend, just to be clear, you saw this chart before you bought your car.
Yes.
Your Honor, permission to publish this as evidence to the jury?
Any objection?
Okay,
Submitted.
You did some more research, is that right, Ms. Townsend?
Yes, like I said, I read an article, saw some ads.
Would you recognize these advertisements if I showed them to you? There were 3.
Yeah.
Your Honor, permission to show the
You may.
witness the ads. And Your Honor, permission to
These
use our
have been
demonstration.
admitted into evidence already, correct?
Yes, Your Honor. 780. And then permission to use our demonstrative.
You may.
Thank you, Your Honor. Sounds we'll get to this one in a minute. Let's start with exhibit 7, sounds. Can you show the jury this? What is this person doing?
Driving a car?
Are their hands on the wheel?
No,
This car looks to be in motion, right?
I guess.
This car is from Alchie Motor or this advertisement's from Alchie Motor Company?
I don't remember specifically.
This car is from Alchie Motor Company, is that right?
I don't remember specifically. I'm sure there's other self-driving cars out there.
Let's move to exhibit 8, sounds. What does this tell you?
What does it tell me? Or
What
does
is
it
this?
show?
What does it show? Can you show the jury as well? Thank you.
It's another person driving a car
Where are their hands?
on their lap.
Is this from Alchie Motor Company?
I mean, there's no indication on this, so I'm not exactly sure.
You previously, or you don't think this is from Alchie Motor Company?
I don't remember.
Ms. Townsend? Your Honor, may I use testimony from Ms. Townsend?
You may call her attention to those portions of the deposition.
Ms. Townsend, on your testimony on August 18th, 2022, question number or line number 14, the question you were asked were, can you identify exhibit 8? Can you show exhibit 8 to the jury? You responded, yes, that's also a specific advertisement for the Alchie automobile. So is this for an Alchie automobile? Ms.
Yeah.
Townsend?
Yes.
Let's move to the final exhibit. I blew this one up for you, Ms. Townsend, and you have it as well. Can you tell us a little bit what's going on in this exhibit?
There's another car driving.
This person seems to be in motion, is that right?
Yes.
Can you tell me what this word means?
What it means
Or what it
says.
says, I'm sorry, thank you.
Self-driving.
Can you tell me what this means?
What it means or what it says.
What it says?
48 miles per hour.
So this car seems to be going 48 miles an hour.
Yeah.
And Ms. Townsend, can you tell me what this driver is holding?
Some sort of book or magazine.
Not a steering wheel.
No.
Ms. Townsend, so you, just to be clear, you saw these advertisements as well as this chart prior to buying the Alchie Model T.
Yes, I did see that.
No further questions, Sean. Thank you.
And then read right.
Yes, Your Honor. Ms. Townsend, I'd just like to clarify some things that were discussed on cross-examination. Opposing counsel asked you if you had seen that chart that you were shown. But did you see that exact chart before purchasing the Alchie Model T?
I don't remember. I mean, I did 6 months of research, so possibly that was in it.
Did you ever read anything that told you explicitly that the Alchie Model T was a level 4 car?
No.
Okay, thank you. No further questions.
May this witness be finally excused.
Yes, Your Honor.
Thank you, Ms. Townsend. You may step down. Plaintiff may call its next witness. Excuse me, defense may call its next witness.
The defense calls Dr. Gary Gleason.
He may come forward now.
Good afternoon. Would you please introduce yourself to the court?
Certainly. My name is Dr. Gary Gleason.
Dr. Gleason, what is your current occupation?
I work for a large engineering firm, and my area of expertise is in advanced technology, specifically autonomous vehicles.
And what does the education background look like for this?
So I attended West Lone Star A&M, where I obtained my bachelor's degree in computer science. And then I went on to get my master's and my PhD, both in biomechanical engineering at the University of Lone Star, San Antonio.
So what did you do after you got your PhD?
I went to work for General Motors. I was there for about 10 years in their autonomous vehicles.
And what did you do in this role?
So I worked primarily on software within autonomous vehicles. Most of my time was spent on a project that we called Penguin.
Is Penguin short for something?
Yes, precision engineered navigation, guidance, unassisted intelligence. So obviously Penguin, a little bit more simple.
Okay, so after you finished at General Motors, what did you do next?
I began my current position.
Have you ever testified in cases like this before?
I've testified in 10 prior cases, so this is my 11th.
And did all 10 of those cases that you investigated involve cars with autonomous driving systems?
They did.
Dr. Gleason, what type of facts and data are sufficient for you to conduct an investigation of such?
When I'm investigating an accident involving an autonomous vehicle, it's really a totality of the circumstances analysis, sort of a holistic approach. So I'm taking everything from photos to accident reports prepared by law enforcement and other entities like the NTSB, records produced by the vehicle, records produced by the driver and any other people involved, the manual and any other material presented by the manufacturer to drivers. And I take all of that and then combine it to come back conclusions.
Were you able to use all of the methods that you just described and the data from those for this specific case?
I actually had a wealth of knowledge, resources in this case.
And is this a common practice within your field?
I think it's not just common, I think it's the only way to do this effectively.
Your Honor, the defense would like to tenure Dr. Gary Gleason as an expert in autonomous driving vehicles.
The objection.
Objection, Your Honor, yes, lack of foundation. We feel this witness has not been qualified under Rule 702. We ask permission to voir dire this witness.
Any objection to voir dire of the witness?
Your Honor, Dr. Gleason just testified to the methods and data that he uses to investigate autonomous driving vehicles.
Right.
He also testified that he is an engineering expert and wasn't at a firm, General Motors, for 10 years. And then where he came now to his current position and has investigated 10 prior accidents involving autonomous driving vehicles. So the defense feels it is more than appropriate for Dr. Gary Gleason to be tenured as an expert.
That may well be. I'm not ruling that he's not going to be accepted, but I do think counsel should have the opportunity to conduct a little voir dire before I make that decision. I'll allow that now.
Dr. Gleason, you went to work for GM right after graduation.
I did, that's correct.
Did you receive any special training in the autonomous systems while at GM?
I've worked on those projects for 10 years. I was considered I would say, a leading person in my field. So certainly a lot of experience and a lot of opportunities to learn from my colleagues and from other experts.
Did you obtain a license while at GM?
Not any specific license. I'm not sure that there's really a specific license in autonomous vehicles. It's sort of a developing field. And so since I was on the cutting edge of it, there wasn't really a licensing process.
Were you required to pass any special boards?
I obtained my PhD in engineering, but beyond that, there's not any additional licensing.
Okay. How long have you worked in your current position?
I've been in my current position for several years.
And this is, your current position is as just a provide expert testimony, correct?
I'm a consultant with an engineering firm.
Your Honor, at this time, we raise our objection as this witness not being qualified under Rule 702. He's been at his current position, has not been at GM for many years now, as the ABS systems in cars is an ever evolving area of technology. And since he has not been involved directly hands-on In the past few years, we argue that he is not qualified as a witness. That's the next one.
Okay, counsel, you may.
Dr. Gleason just said that he worked at General Motors for 10 years, working with autonomous driving vehicle, a new and upcoming technology that has come to the field today. And he also testified that he has been at his current role with the engineering firm for several years. We believe that Dr. Gleason, in his leading facts and data that he collects in regards to autonomous vehicle, he's on the cutting edge. He is at the top of the expertise involving autonomous vehicles. Therefore, we determined that he is qualified to be an expert in autonomous driving vehicles and testify at the trial today.
Anything further, counsel? Okay, the objection will be overruled. I believe he does meet the standard to be accepted as an expert in the field of autonomous driving
Yes, sir.
vehicles. Counsel, you may proceed.
Dr. Gleason, you just discussed the data and facts that you have collected. And with those that you collected for this case, were you able to reach a conclusion?
I was actually able to reach two distinct conclusions in this case.
Since you were able to reach two, let's start with the first. What was your first conclusion?
My first conclusion was the accident here was caused by a combination of Ms. Manager's failure to yield the right of way and the driver's inattentiveness behind the wheel of the Audi Model T.
So we'll get to the driver's inattentiveness in a minute. What makes you say that Ms. Manager failed to yield at the right of way?
So based on the diagram of the crime scene produced by the investigating officer, as well as testimony from Ms. Townsend and Mr. Goucher, I believe that Ms. Manager was exiting a fast food restaurant and proceeded to accelerate on her bicycle into oncoming traffic.
And Dr. Gleason, you said that you came to two conclusions. What was your second?
My second was that the 2020 Audi Model T was not defective in its manufacture, its design, its implementation, or its marketing.
So in the facts and data that you reviewed for this case, you said that you reviewed did you review the owner's manual?
I did. I actually reviewed the entire owner's manual.
If I showed you a copy of the owner's manual, would you recognize it?
Sure.
Your Honor, the defense is retrieving what is previously entered as exhibit 6. Dr. Gleason, what have I handed you?
This looks to be sections from the 2020 Model T owner's manual. Like any serious expert, I actually reviewed the entire manual during my investigation.
And Dr. Gleason, could you turn with me to page 314 of this manual? And can you read the second paragraph that is contained under the caution?
Yes, it says auto steer is a hands-on feature. You must keep your hand on the steering wheel at all times.
Dr. Gleason, what does this information mean in terms of the analysis that you conducted for this case?
It makes it extremely clear what the responsibility is of the driver of one of these autonomous vehicles. In this case, the driver is specifically instructed to keep their hands on the steering wheel at all times. Based on the report from the NTSB, we know that Ms. Townsend had her hands off of the steering wheel for at least 34% of the time while the auto steer function was operating. So in other words, she was clearly ignoring these warnings provided by Audi.
And Dr. Gleason, could you please turn to the next page, page 315?
Certainly.
Can you read this section under warning with the caution symbol, the paragraph?
Yes, it says warning, it's got a caution sign and a big black bar. Navigate on autopilot does not make driving autonomous. You must pay attention to the road, keep your hands on the steering wheel at all times, and remain aware of your navigation route. And then it's bolded, and it says, do not take your eyes off the road for extended periods of time. Do not remove your hands from the wheel at any time.
And Dr. Gleason, furthermore, could you read these two paragraphs, both listed under the red warning signs?
Certainly. So like you said, there's a big red bold warning, and it says, as is the case with normal driving, be extra careful around blind corners, interchanges and on-ramps and off-ramps. Obstacles can appear quickly and at any time. Then another big red bolded warning sign, navigate on autopilot, may not recognize or detect oncoming vehicles, stationary objects, and special use lanes, such as those used exclusively for bikes, carpools, emergency.
So, Dr. Gleason, what is this information contained within the owner's manual? How does that add to the analysis that you've used to reach your conclusion?
So once again, it makes it clear what the responsibilities of the driver are. And in this case, it makes it clear that Ms. Townsend should have kept her eyes on the road at all times. We know based on her phone records that she was sending and receiving texts in the moments leading up to this accident. This section of the owner's manual also makes clear that Alchie does not, is not saying that their sensors are sensitive enough to detect certain objects, including bicycles. In this situation, the Alchie sensors actually worked better than what Alchie told an owner in their owner's manual that they would.
And Dr. Gleason, I'll retrieve that owner's manual from you now. You also mentioned that you used the recorder data from the car. Was that the recorder data used for the car that Ms. Townsend was driving?
Yes, it was.
If I showed you a copy, would you recognize it?
Absolutely.
Your Honor, the defense is retrieving what has previously been entered as exhibit 15. Dr. Gleason, what have I just handed you?
This is that recorder data from the 2020 Alchie Model T.
Yes, and there are quite frankly a lot of numbers and lines listed on this chart. Could you please make sense of this information for the court today?
Absolutely. So the first thing I'll direct your attention to is here in column 4 where it says sensors activate. So just like I was mentioning, the entire time, beginning 2.6 seconds before the collision, the sensors on the Alchie Model T did detect the obstacle. That doesn't change. The sensors continue to be activated throughout this entire lead up to the actual collision. So that's the first thing to note. The second to note here is that at 2.6 seconds, the brakes begin this period of cycling on and off. Now, the auto steer on this model of car is designed to be used on divided highways. That means that there are cars changing lanes, they're not expecting cross traffic. If you were on a divided highway and traveling at speed and something was to move towards you, you wouldn't want the car to immediately slam on the brakes. That could cause serious issues. So instead, what the car does here is sort of come to a stuttering stop in an attempt to alert the driver, to tell the driver, hey, you should look out the window and see what's coming towards you. We see that happening for a full 2 seconds, and yet nothing on this chart indicates that Ms. Townsend took any action at all to become aware of what was going on or to stop the vehicle. And then finally, at 0.6 seconds before collision, the Alchie engages effectively an emergency brake in an attempt to avoid the collision because Ms. Townsend had not been attentive.
And Dr. Gleason, based on your analysis for her attentiveness, does your analysis also provide anything in terms of the time?
So like I said, there's 2.6 seconds here where the Alchie first identifies the obstacle and a full 0.6 seconds before it fully engages the brakes. It fully engages the brakes at 0.6 seconds. So that's a full 2 seconds between when the obstacle was detected and when the brakes were engaged. That's more than enough time for Ms. Townsend to have done something to prevent this accident.
So, Dr. Gleason, you do believe that, do you believe?
I believe that Taylor Townsend had more than enough time.
No further questions. I'll retrieve that, please.
Good afternoon, Dr. Gleason.
Afternoon.
I'm just gonna ask you a few questions, okay?
Sure.
Let's begin by talking about how you came to this case for today. You work for a company that specializes in providing expert testimony, correct?
That's true.
You make a living by testifying in court.
In part, yes.
You are paid, you're being paid by Alchie to be here today.
I'm being paid a nominal fee, yes.
You wrote an article for a magazine named Motor Trend.
I've written a ton of articles for Motor Trend over the years.
Would you recognize this article if I showed it to you?
Probably so.
Your Honor, approaching opposing counsel was going to mark exhibit 10. This is that article, isn't it, Dr. Lee?
This is an article that I wrote half of and Dr. Evelyn wrote the other half of.
Have there been any material alterations or changes made to the article that you wrote in this?
To my section, not that I'm aware
So
of.
this is a very inaccurate copy, isn't it?
I believe so.
Your Honor, at this time, plaintiff has had exhibit 10 admitting to evidence.
Counsel,
Oh,
it's admitted.
Dr. Gleason, will you please read the first two paragraphs of your article for the court?
Yes, it says despite a rash of crashes recently, the National Association of Car Manufacturers has again announced that so-called self-driving cars are dangerous. Proof is in the pudding, as they say, and there's mounting evidence that these autonomous driving systems come up short. Look at recent crash data. Ouchie's ADS cars have recently been involved in accidents. Wilson, Florida, Culver City, California, and Delray Beach, Florida. Each of the accidents resulted in fatalities. In each instance, the USP investigator determined the ADS system was to one degree or another a causal factor in the accident.
Thank you, Dr. Uncle. The opinions you espouse in this article, you don't believe them anymore, is that correct?
I don't, and I would add that in the actual.
You don't believe these anymore, is that yes?
Those opinions are more than 4 years old, and so.
You stated that you were goofing around.
Objection, Your Honor. Counsel is not allowing the witness to testify today.
Allow the witness to finish his answer before asking the next question.
There have been significant increases in technology since 2020 when that article was written. The idea that I would still believe the same things about an innovative technology like ADS 4 years later is kind of ridiculous, frankly.
You were just goofing around when you wrote that article.
Like I said, I get asked to write a whole lot of articles, and some of them I pay a little bit more attention than others.
You've previously stated that you were just goofing around on this specific article.
This was one that I was asked to write, and I didn't take a lot of time in writing. No.
Is that a yes?
Sure.
You did state that you were just goofing around.
Yeah, like I said, I've gotten asked to write a lot of these, and this is one that I didn't take very much time on.
I mean, this article that you were just goofing around on, it explicitly mentions the deaths of 3 people who were driving out your vehicles.
Yeah, you know, actually, those cases, the NTSB found that the deaths were because of driver inattentiveness, as well as some other, failure to yield right of ways.
You think it's appropriate to goof around when discussing the deaths of people driving out your vehicles?
Gotten asked to write a ton of articles. It's hard to take every single one of those requests as serious as mine should.
Sure. But you're being serious with us today.
Absolutely.
Let's move on. Let's talk about these advertisements. Dr. Gleason, you have stated, and I'm quoting, that anyone with a shred of intelligence would not actually believe that they could take their hands off a steering wheel.
That's correct, and I stand by that.
Your Honor, permission to display this demonstrative of Exhibit 9, which has already been admitted into evidence,
You may.
as well as Exhibits 7 and 8. Dr. Gleason. Does this driver have their hands on the steering wheel?
It looks like some of that advertising fluff that I've seen before.
Does this driver have their hands on the steering wheel? Yes or no?
No, no,
Does this driver have their hands on the steering wheel? Yes or no?
no, once again, it's more of that fluff.
Does this driver have their hands on the steering wheel?
Are you, no.
Did they have their hands on
This is
something then?
ridiculous.
They have their hands on something, don't they?
This is,
Your Honor. Counsel is not allowing the witness to testify.
Your Honor, the witness is being non-responsive to my questions. I asked for a little bit of latitude.
Just repeat the question and I'll let the witness answer.
This driver does not have their hands on the steering wheel, do they?
no, it's clear this is an exaggeration.
This is a book, not a steering wheel.
It looks like a magazine to me.
Sure, some sort of reading materials, right?
Sure, like I said, it's a clear piece of fluff, exaggeration.
Yes. So Alchie Motor Company depicted drivers without their hands on the steering wheel, correct?
There was exaggeration in some of those stats, for sure.
Let's move on. Let's talk about the NTSB that you have mentioned. You are familiar with this NTSB report about the July 6th crash, correct?
I am, I agree with parts of it, disagree with other parts.
Your Honor, I'm approaching the public counsel was already admitted to evidence of Exhibit 14. Dr. Gleason, I will direct you to page 5, titled Findings in the Armadillo Accident. Have you seen that? Are you at that page?
Yes.
Will you please read number 6 aloud for the court?
Yes, and just to make it clear, this is what the NTSB found, not what I found. If Ouchie Incorporated does not incorporate system safeguards that limit the use of autopilot system to those conditions for which it's designed, continued use of the system beyond its operation and design domain is theoretically foreseeable, and the risk for future crashes may remain.
So the NTSB believes that the risk of future crashes remains
The
based on number
NTSB
6.
The NTSB is saying that, if drivers continue to use the car in a way that's not designed for, like Ms. Townsend did, then certainly, if I was to take a golf cart on the highway, it's very possible that an accident would result. That's not the fault of the golf cart
To
manufacturer.
be clear, doctor, it says if adequate safeguards are not implemented. That would be on the part of Fauci,
It
would it not be?
says, those conditions for which it was designed, and it says continued use of the system beyond its operational design domain. The operational design domain is referring to the lanes where a car is supposed to be driven, right? So in this case, a divided highway.
Dr. Gleason, that's not the question I asked you. Number 6, on findings in the Armadillo accident, will you please read that once more?
Yes. Fauci Inc. does not incorporate system safeguards that limit the use of the autopilot system to those conditions for which it was designed. Continue the use of the system beyond its operational design domain. Compromise value is theoretically foreseeable and the risk for future crashes may remain.
Thank you. Moving on, I just have a few more questions for you. You're familiar with this chart,
Absolutely.
are you not? You're on permission to display or motion.
But
You are well versed in these systems, correct?
I am.
And you did say that the Algae Model T, in your opinion, is a level 4 system.
That's correct. So what that means is that it has ODD
That's
specific automation.
So briefly for the jury, walk through this.
Could I have a copy that I could actually see?
Sure. Systems, level 0 through 2. In these systems, drivers will perform, all are part of the dynamic driving test, correct?
That's sort of a generalization, but sure.
This is why it says to the right, driver is responsible for these tasks, correct?
Yes, that's correct.
Moving further down, ADS systems ranked 3 through 5. The DDT, the dynamic driving task, is all in part or in wholly on the system, correct?
That's right. So it depends on the ODD for levels 3 and 4. And if you'll note level 5, which this car is not, is sustained and unconditional. And it actually says in parentheses, not ODD specific.
This car is a level 4 in your opinion.
That's right. So that
Well,
means.
since this
it's
car is
ODD
level
specific.
4, will you please read for us?
allow the witness to finish his answer.
This car is level 4 in your opinion,
That's
correct?
correct.
Since you, in your opinion, is a level 4, will you please read for us the definition of a level 4 system?
Absolutely. The sustained and ODD specific performance by an EDS of the entire DDT and DDT fallback without any expectation that a user will respond to a request to intervene.
Without any expectation that a user will respond to a request to intervene.
For that ODD specific performance, yes. Once again, ODD is referring to where it's supposed to be driven. That's referring to on a divided highway with no cross traffic.
So in a level 4 system, the system itself is responsible for sustained lateral and longitudinal vehicle motion control, yes?
Within the ODD where it's supposed to be driven, yes. Outside of that, no.
Sure. OEDR, will you explain to us what that is?
That's object and event detection and response. That's sensing things outside of the vehicle.
In a level 4 system, the system itself is responsible for detecting objects and events.
Once again, within the operational design domain, yes. Outside of that, no.
An object, a bicycle is an object, isn't it, doctor?
It is, and within that operational design domain, if this was on a divided highway with no cross traffic, then the car would be responsible for that.
And Ms. Townsend, to be clear, was operating a level 4 Algae Model T.
Outside of the ODD specific, the design domain was designed, yes.
And in a level 4, there is no expectation that a driver will respond to an object of the road or a request to intervene in a level 4 system.
That expectation exists when you're operating within the ODD. It does not exist, the expectation that a user will intervene exists when operating outside of the ODD. It does not exist when operating inside of the ODD. Ms. Townsend was operating outside of the ODD, so the expectation was that the user would intervene.
No further questions, Your Honor.
Can you redirect?
Yes. Dr. Gleason, you have just been asked to describe the defects in the Alchemy motoring system. You were in the courtroom today when Dr. Kathleen and Taylor Townsend testified. Were you?
Yes, I was.
What do you think about the testimony offered by Dr. Evelyn?
I think Dr. Evelyn talked a lot about, what he might have added to the car, but nothing serious about what the car was actually able to do. He described all these additional systems that might make the car more likely to sense an obstacle. But the car sensed the obstacle in question. He described systems that might make the car more likely to warn the driver, but the car warned the driver. So frankly, I think most of his testimony is sort of irrelevant.
And you were also in the courtroom when Taylor Townsend
I
testified.
was, yes.
What do you have an opinion about the testimony that she offered today?
I was particularly bothered by the fact that it seemed clear she
Objection,
didn't
Your Honor.
have.
This is beyond the scope of this witness's expertise. He's testifying as to his opinion on testimony. He's been tenuous and expert in the field of ADS technology, and this is beyond the scope of that expertise, Your Honor.
You may respond.
The expert was never sequestered. Dr. Gleason sat in the courtroom today as Taylor Townsend testified. And as a result, he is able to form an opinion based on his analysis and her testimony today.
Anything further,
Your
counsel?
Honor, this is an opinion of an expert, and his presence in the courtroom has no bearing on his ability to give an opinion as to what he thinks about Ms. Townsend's statements.
I'll overrule the objection and allow the testimony.
Dr. Gleason, my question, do you have an opinion on the testimony today that you heard from Taylor Townsend?
I do. After all of the reading I did and all of the information that confirms that drivers are supposed to pay attention, supposed to have their hands on the steering wheel, I'm really bothered that she would sit here and tell us that she didn't grab the steering wheel until a collision actually happened.
No further questions from me. Thank you, Dr.
Okay.
Gleason.
Thank you. You may, witness may step down and is excused. Does the defense have any additional witnesses?
No, Your Honor, at this time, the defense rests its case in chief and will request of the board a brief recess to prepare for closing arguments.
All right, any objection to a brief recess?
No objection.
How much time do you need?
Are we amenable to 10 minutes?
10 minutes? Okay. Court will stand in recess for 10 minutes.
Thank you.
Thank you. You see me sweating up here?
It's not being, they're not welcome, but we all have the same right over there. Your line of here. Oh, this up with them. 2 months. I don't want. I don't want that there. I want my rule well. No. Name's real name.
Yeah. Y'all have 8 minutes and 41 seconds. And the plaintiff had 10 minutes and 7 seconds. I'm redoing all this right now, just to be sure.
Okay.
Adverse possession case. That's how I told her, when she was telling about what's going on with the blood, I don't know, but it's not like you're land from somebody, like deeds and everything. Moves on the land, I live.
Yeah, I mean, and then turn off everything else.
Yeah. Apparently like 8 years ago, and I'm like,
That's all
that's all, like, she doesn't live right now, but I'm you got to start with that.
It almost had 19,
She runs, yeah, runs the clinic, and I'll be like,
We're not.
you need a shot. I
Never had to again. I never want to see them again.
Then they got their sheet on the back here for now. She was on the
Wait,
and everyone's wondering, oh, no, I'm certain, like, they said, you know, like, what's going on. They're gonna go in, they, it's hard, and on now, like. I'm gonna. No, it's, you know,
Water, okay. Yes, sir, I can get right on that. Appreciate it. Can you run down to the library and get 5 waters? Thank you so much.
Okay, so I'll just move it up. I may have delegated to that.
Good job, Bryce. And I'll move this. Who asked me?
Anywhere.
Yes.
I've got some great pictures of that.
Thank you, man. I might need all facts. At least be at profile. Bring it home. No pressure.
Want 5, 4, 3, 2, 1?
I mean,
Y'all have 9 minutes and 7 seconds.
thank you.
Don't. 5, 4, 3, 2, 1.
Yeah. Anything. And if you don't like my second, you keep so like.
This one goes like a little further.
This one. I love this one so much.
There's some up there. I didn't try to. There's one up there on the scene.
Very, very.
Dude, I like the way it's. This one, yeah, I like Yeah, I guess, yeah, some people probably do too, so it's quite scary. But, yeah.
If I can get it on the line side.
Yeah.
Yeah.
Yeah. I agree.
They can always learn out.
Yeah.
You're all talking about it. I'm so glad we did this because they've got to get our like first year. You know what I mean? Yeah, I think for sure. When it's like, everybody that come out and say how it went, we all shared nicely. Yes.
All rise. You may remain seated. I apologize.
Court is back in session. Our counsel ready to proceed with closing arguments?
Yes, Your Honor, plaintiff is ready to proceed.
Your Honor, the defense is also ready to proceed.
Okay. Counsel for the plaintiff?
May it please the court. Your Honor. Opposing counsel. Members of the jury. When a company puts profits over people, people die. When a company sacrifices its safety, it gambles with people's lives. Alchie Motor Company gambled with Laura Minger's life, and Laura lost. I want to be very clear about this right now. Laura Mininger is dead because of Alchie Motor Company. The death of this young woman is a tragedy, but it would be an insult to her memory to call it an accident. Laura Mininger is dead because Alchie Motor Company put profits over people. See, this company assured us that their Model T was the car of the future. They told us it was safe and reliable. But underneath all the false advertisements, fake promises, they hid a bitter truth. It was all a lie. Alchie lied, and Laura died. Now, you've heard a lot of information in this case today. And I must admit, it does get a little confusing when you hear phrases like operational design domain and dynamic driving tasks get thrown around. These are exactly phrases that come up in everyday conversation, I understand. But if you look at the evidence, with the common sense that I'm confident you all have as members of this jury, there are only three conclusions that you can draw in today's case. The Alchie Model T had a marketing defect, and the Alchie Model T had a defect in its design. And it is more likely than not that it was these defects that produced the death of Miss Laura Mininger. More likely than not. That's all it takes. See, if you're only slightly more convinced that Alchie is to blame for this horrible tragedy, then we will have met our burden as the plaintiff in this case. So what is the evidence tell you? I would like for you all to take a moment and look at these advertisements just one more time. Not a single one of these depict a driver with their hands on the steering wheel. Not a single one of these depict the car operating the way Alchie tells us it's supposed to. It's like a company advertising a new sofa and then telling you that you should have sat on it. This is blatant deception. And yet the truth is right in front of you, folks. You see, these advertisements here, they help sell cars. And that's all that Alchie was worried about anyway. And now a woman is dead. And they have the audacity to come here and tell you that she is only dead because their customers are too stupid. Taylor Townsend is stupid. Taylor Townsend purchased the Alchemy Model T because she truly believed it would make driving safer for her passengers and for herself. Miss Townsend relied on the information that Alchemy put out there. See, the only thing that Miss Townsend did wrong was put her faith in them. And meanwhile, Alchemy could care less about people like Mrs. Townsend. She lost their affection as soon as they received her check in the mail. And we also know that Alchemy cut corners when making this car. If only they had taken the reasonable steps to ensure its safety, we would not even be here today. Dr. Carrie Evelyn told you about 3 simple design changes that, if implemented, would have prevented this tragedy. Alchemy Motor Company should have placed the appropriate number of sensors in front of the car that would have been able to detect Miss Vinegar's bicycle in time. They didn't do that. Alchemy should have designed the software so that the impact mitigation system would have automatically stopped the car. And they didn't do that. Alchemy Motor Company should have implemented a driver engagement system. And they didn't do that either. If any one of these design defects would have been addressed, Miss Vinegar would be at home with her family right now. So why did they do it? Well, folks, the unfortunate truth is that Alchemy was too concerned with profits to care about people. Any one of these design defects that I just mentioned to you could have been solved at a minimal cost. And yet Alchemy ignored these defects to say pennies on the dollar. Because at Alchemy Motor Company, price is measured in dollars and cents rather than the price of human life. You see, they'd rather spend their money on attorneys and expensive experts. And I want to be clear about this right now, ladies and gentlemen. This so-called expert that you heard testify for Alchemy today, he was not here to seek the truth. He was here to collect a paycheck. Every word you heard him utter was bought and paid for by the defendant. Every word designed to protect the interests of those who hired him. How could you place your trust in someone whose loyalty lies not with justice and truth, but with money? That was not expert testimony. That was a paid performance. And as members of this jury, you all deserve better than to be swayed by the opinions of someone who profits from lying to you. What you deserve is the truth. Now I'll leave you with this. In a few moments, this board is going to instruct you on how to apply the law in this case. You're going to be handed a verdict sheet that looks just like the one I'm holding now. But when you receive this document, understand that what you're holding is more than just a verdict sheet. What you will be holding is the power to make a change. You'll be holding the power to make this world a safer place for every single one of us. If you believe it is more likely than not that the Alchemy Model T contained a defect, and it was this defect that caused the death of Miss Manning, all you have to do is check yes on this line right here. Laura Mander was 20 years old. She had an entire life ahead of her. And now she's gone. Right yes for Laura. Her family, they'll never see her smile again. And they'll never feel her warmth. Right yes for their suffering. Right yes for every single person that this company could hurt in the future if they are not forced to change their ways. Right yes to tell Alchemy that enough is enough. Right yes because you believe that people must always come before profit. Ladies and gentlemen, right yes, not because I'm asking you to, but because that feeling inside you, the one that knows what is right from what is wrong, it tells you to right yes. In the name of justice, find Alchemy Motor Company liable for this tragedy. And right yes. Thank you.
Counsel,
Yes, Your Honor, permission to come back to Well for closing argument?
granted. You may proceed.
Your Honor, opposing counsel, members of the jury. May it please the court. She had more than enough time. Taylor Townsend, the driver of the LG Model T on the day of that terrible accident, had more than enough time to prevent Miss Laura Meninger's death. But because she ignored warning after warning after warning, because she didn't take any evasive action whatsoever, because her apathy finally caught up to her, a woman lost her life. And she didn't have to. Today, the plaintiff has brought against Alchi Motor Company a claim of strict liability. That means that it was their burden to show you that it is more likely than not that some marketing or design defect of the 2020 Alchi Model T was a substantial cause of Ms. Meninger's death. And importantly, Your Honor, and members of the jury, that without this so-called marketing or design defect, the injuries would not have occurred. Now, we the defense, we didn't have to come to court and prove anything to you at all today. But because the evidence was so compelling, we brought before you an affirmative defense of comparative negligence, meaning that we took on that same preponderance of the evidence burden, showing you that it's more likely than not that someone other than Alchi Motors was responsible for Ms. Meninger's death. And we've done that. We've shown you that Taylor Townsend had more than enough time to prevent this accident. And that Alchi provided warning after warning after warning, and if she only heeded them, Ms. Meninger would not have died. We the defense, we understand the plaintiff's need to find someone to blame. A man lost his wife. But when you're searching for fault, it's very important to make sure that you're putting the blame on the right party. And today that blame lies squarely on the shoulders of Ms. Taylor Townsend. But let's take a moment to talk about what exactly it is that the plaintiff tried to prove to you today. They tried to tell you that there was some type of marketing defect with the Alchi Model T. Now, importantly, in order to prove a marketing defect, they had to show you that a reasonably prudent person would have believed what they are reporting. But you met Ms. Taylor Townsend today, members of the jury, and a reasonably prudent person, she is not. As drivers on the road, we are required to uphold a standard of ordinary care, which means that we have to keep our eyes on the road. Remember that she was awarded a ticket for failure to control her vehicle, because ultimately, at the end of the day, she was the one operating the car. Now, the plaintiff showed you all kinds of ads that show somebody not paying attention and reading a book, but blaming Alchi for someone believing something that outlandish would be the same thing as if Miss Townsend chugged a can of Red Bull, jumped off of a cliff, and then blamed Red Bull because she didn't grow wings. A reasonable person wouldn't have believed that they could sit in a car and read a book. But Alchi told everyone what they needed to know. They warned their customers. They also told you about a design defect that they claim would have happened, but no matter what fancy doodads and gadgets and gizmos that you added to that car, nothing could have accounted for a driver like Taylor Townsend. You remember from the testimony of Dr. Gary Gleason that the car actually did stop. And the car actually did do something that should have engaged a driver. And those are the functions that the plaintiff said the car should have performed. You heard that the car stuttered and the brakes turned on and off and on and off like trying to brake on an icy road. You also heard that a driver who was paying attention would have been able to stop the car in time to prevent the accident. Algae did everything it was supposed to do. The company was aware of its limitations, members of the jury. They put them right there in the owner's manual. Now, the plaintiff's expert didn't even bother to read the entire manual, but you saw warning after warning after warning about the limitations of the system. Keep your eyes on the road, keep your hands on the steering wheel, be prepared to take over at any time. Ms. Townsend didn't think it was important to read any of this. But even if you don't believe that, she should have read the manual. She didn't have to be warned. Because every single time Ms. Townsend activated that autonomous driving system, she had to make acknowledgments. I want to take a little bit to walk through all the acknowledgments that Ms. Townsend had to make every single time she activated that autonomous driving feature. So on the day of the accident, she had to acknowledge that she should not take her eyes off the road for extended periods of time. Well, you heard testimony today that she was texting and driving during that ride. So no, her eyes were not on the road. She also acknowledged that she should not remove her hands from the wheel at any time. Well, you heard her on the stand today saying that right before the crash, she actually had to grab the steering wheel. So no, she didn't have her hands on the steering wheel the entire time. Ms. Townsend had to acknowledge that auto steer is designed for use on highways that have a center divider, clear lane markings, and no cross traffic. She was in the middle of an intersection, right outside of a burger bar, certainly not a highway, and certainly cross traffic. If Ms. Townsend had heeded this warning, the autopilot system would not have been in use at all, and this entire thing could have been avoided. But what else did Ms. Townsend have to acknowledge? Well, she had to acknowledge that she should always pay attention to the roadway and be prepared to take immediate action. Well, you heard a testimony from two expert witnesses who said that she took no evasive action whatsoever. Ms. Townsend told you that she saw the bicycle out of the corner of her eye, and she just sat there. That's not just negligence. Members of the jury, that is apathy. Ms. Townsend did not behave as a reasonable person would, with care for human life. The ordinary care that we expect of anybody on our roadways. So no matter what Algae changed to its design, to its system, no matter what it added or subtracted, they couldn't have accounted Taylor Townsend, who refused to take any accountability at all. But members of the jury, you have a decision to make. At the end of the day, what we're doing here is apportioning fault for this incident. So you're gonna get a jury instruction form that looks a little bit like this. I want to take a moment to walk through it with you. Now, we have established that there was any marketing or advertising defects were not a producing cause of the injury because Taylor Townsend ultimately had the responsibility to stop the car. So here, we're gonna write no. But just in case, Your Honor, we'll walk through the rest of it. Now we have to decide if any of these people had anything to do with the injury. So we're definitely gonna write yes for Taylor Townsend, because she had more than enough time to stop the vehicle. Think about it. 2.6 seconds, that's 1 Mississippi, 2 Mississippi, plus a little bit more. More than enough time to slam on those brakes. So then, on question number 3, we're gonna assign Taylor Townsend 100% of the blame, because she ignored every single warning Algae gave her. You should find Algae not liable. Thank you.
Rebuttal argument?
As you would expect. Counsel for Algie stand before you, pointing fingers in every direction at themselves. Look here, look there. But you've heard the evidence. You know the truth. It is time to hold Algie accountable for their own defects. It is time to look them in the face and say it's time for you to look in the mirror. I'll leave you with this. Taylor Townsend was fooled by Algie. Taylor Townsend is just like you and me. She wanted a car that was safer, and she wanted a car that she believed could do more. And Algie took advantage of that. And now is the time to hold that company accountable. Thank you.
All right, thank you. Jury will now retire for deliberations, and I believe the plan is to come back and announce, Lanny, just remind me, correct me if I'm wrong, but the plan is to come back and announce a winner. And then the participants have the opportunity to receive any feedback from the jurors and me.
We do the feedback.
Feedback will be in private in court, in the small courtroom. Court will be in recess.
I get told that they were quite hard to beat.
There we go. There you go. Yeah. Abby, Marcy, you can honor me. You can honor me. The room will be like.
Sorry.
All in that. Now, here's your. Where's that?
Perfect. Thank
You.
Thank you.
Y'all too. Y'all been on.
We'll have wheels in the middle. Put them in the middle, they kill it. Personally.
Perfect, great. Y'all are doing awesome, absolutely. Yeah, really awesome.
You know, Bryson, I'm gonna go second. That's all you have. So close, see, so.
Please be seated. Congratulations on a job well done, everybody. It was very, very impressive performance by every attorney who participated in this and the witnesses. But after deliberations, and it was a close decision, a split decision. Not everybody voted the same, but the prevailing party is Council for Algie. So yes, that's you. So that's the decision of the jury and the court. Congratulations, and thanks for everybody in the gallery for coming and watching. These attorneys did a great job, and we will meet the attorneys if you wish to hear any feedback from the jurors and myself in the small courtroom. And with that, we are adjourned. Thank you.
Yeah.